Welcome to an Alliance for Justice Advocacy Short. This brief presentation discusses the different types of tax-exempt organizations and their benefits and limitations related to advocacy. To access Alliance for Justice's extensive resources designed to support your organization's lobbying and election activity, register for one of our regularly scheduled live or web-based workshops, order or download our plain language publications, or forward a question to our on-call attorney by visiting us on the web at www.afj.org. We'll begin our presentation by looking at a variety of tax-exempt organizations and their tax code implications. We will consider each organization's purpose, their tax treatment, and any limitations on their lobbying and election activity. First, we will address 501c3 organizations. 501c3s, commonly referred to as public charities, are organizations created for the purpose of conducting religious, educational, charitable, scientific, literary, or other activities. Also, included in this category are private foundations. They are subject to greater restriction than public charities, and these differences will be noted as we proceed. Examples of 501c3 public charities include Alliance for Justice and the League of Conservation Voters Education Fund. Examples of 501c3 private foundations include the Ford Foundation and the California Endowment. 501c3 organizations are tax-exempt, meaning that they are exempt from paying federal income tax. Also, one of the premier benefits of 501c3s, unique to the rest of the tax-exempt world, is that contributions to 501c3 organizations may be tax-deductible to the donor. For those taxpayers who itemize deductions on their federal tax returns, contributions to 501c3 public charities may be deducted up to 50% of the individual donor's adjusted gross income, whereas contributions to 501c3 private foundations may be deducted up to 35% of the individual donor's adjusted gross income. This deduction, a tax benefit to the donor, is specific to contributions made to 501c3 organizations. As a result of this tax deductibility, 501c3 organizations have a few more restrictions than the rest of the tax-exempt community. 501c3 public charities are limited in how much lobbying they can do. While these limitations are fairly generous, the amount of lobbying an organization can engage in depends on the method the organization uses to measure its lobbying. 501c3 public charities may choose to measure their lobbying under the insubstantial part test or the 501h expenditure test. These tests and the definition of lobbying are discussed in other advocacy shorts. 501c3 private foundations face more restrictions on lobbying. They're subject to substantive taxes on any money they spend themselves on lobbying and, when they direct a public charity, to use grant funds for lobbying activity. However, they can still fund other organizations that lobby. The rules for doing so are discussed in other advocacy shorts. 501c3 organizations may not support or oppose any candidate for political office. This is an absolute prohibition for both public charities and private foundations. That said, there are a whole host of nonpartisan election activities that 501c3s can engage in, such as voter registration drives, get-out-the-vote activity, candidate questionnaires, candidate debates, etc. However, that activity cannot look like, feel like, or smell like it is supporting or opposing a candidate for office. This prohibition applies to all public office elections, from President of the United States down to your local school board or sheriff. Now that we've gone over the characteristics of 501c3 organizations, let's move on to 501c4 social welfare organizations. Examples of 501c4 social welfare organizations include Alliance for Justice Action Campaign and the League of Conservation Voters. You will note that Alliance for Justice has both a 501c3 and a 501c4 organization. We will explain why in one moment. 501c4s are tax-exempt, meaning they are not subject to federal income tax. However, contributions to 501c4 organizations are not tax-deductible. Tax-deductible contributions are unique to 501c3 organizations only. As a result, 501c4 organizations face fewer restrictions than 501c3s do. 501c4s can engage in an unlimited amount of lobbying activity. For example, the sole purpose of a 501c4 could be to lobby. We mentioned earlier that Alliance for Justice has both a 501c3 organization and a 501c4 organization. The reason for this is because our 501c3, Alliance for Justice, was hitting up against our lobbying limits and we wanted to engage in more lobbying activity. By adding an affiliated 501c4 organization, the Alliance for Justice Action Campaign, we have created more capacity to lobby. It is important to note that without the tax deduction for donors, 501c4 organizations often have more difficulty raising money as compared to a 501c3. In terms of election activity, 501c4s may engage in all of the nonpartisan election activity that is permissible for a 501c3 organization, and a 501c4 may also engage in a limited amount of partisan activity, which is activity that supports or opposes a candidate for office. All the federal tax code says in relation to 501c4 partisan political activity is that this activity must be the secondary activity of the organization. It cannot be its primary activity. While the IRS does not specifically define the difference between primary and secondary activity, most tax practitioners believe that a 501c4's partisan political activity must be something less than 49% of its activities and spending to satisfy this law requirement. In addition to tax law, 501c4 organizations that engage in partisan political activity must also follow federal and state election law restrictions, depending on whether they are acting to influence a federal or state or local election. One final note before we move on: there are over 30 different types of tax-exempt organizations. Generally speaking, all of the other types of tax-exempt organizations, except 501c3s, are treated like a 501c4. So, for example, unions, 501c5s, and trade associations, 501c6s, can engage in an unlimited amount of lobbying and can engage in some partisan political activity, but their donors cannot deduct contributions from their personal income tax. The final category of tax-exempt organizations that we will discuss are political organizations. Political organizations, entities that engage primarily in partisan political activity, are organized under Section 527 of the tax code. This section of the tax code is the kitchen sink for political organizations. It includes candidate campaigns, national and state political parties, and federal and state PACs, among others. For purposes of this conversation, we're going to focus on two types of 527 organizations called federally registered political committees, more commonly known as federal PACs. There are two types of federally registered political committees: connected PACs and independent PACs. Connected PACs, as their name implies, are connected to an underlying organization, for example, a 501c4 or a 501c5. Connected PACs can never be connected to a 501c3 organization because 501c3s themselves cannot engage in partisan political activity. A connected federal PAC solicits contributions from the membership of the connected organization only, and the connected organization may pay for the PAC's administrative expenses. Independent PACs, as the name indicates, are set up independently of any other organization. The largest independent federal PAC in the country is Emily's List, which was created by Ellen Malcolm and others exclusive of any relationship to another organization. Independent PACs may solicit contributions from the general public, so they are typically larger than a connected PAC. Federally registered political committees, indeed all 527 political organizations, are tax exempt, but contributions to them are not tax deductible. Federally registered PACs and all other 527 organizations may engage in a limited amount of lobbying. To the extent that their lobbying becomes substantial in nature, that activity will be subject to a tax. Generally speaking, political organizations rarely engage in lobbying activity. Federally registered PACs typically are organized to influence elections directly through support or opposition of candidates. They make direct or in-kind contributions as well as issue communications in support or opposition of a candidate running for office. These activities are governed by federal and state election law. We hope this information on the types of tax-exempt organizations is helpful to you. For more detailed information on the rules governing nonprofit advocacy, please go to our website at www.afj.org, read our publications Being a Player and Worry-Free Lobbying for Nonprofits, or contact our on-call attorney for technical assistance. Alliance for Justice has offices in Washington, D.C. and Oakland, California. Please contact us if we can be of further assistance to you. Thank you for listening to our Advocacy Short.